They tried to break him, but they didn't realize his soul was made of titanium and fire. Witness the incredible resilience of a human spirit that refuses to be contained or controlled. Hit subscribe today and find the unbreakable power within your own heart.
My stepfather's lawyer leaned across the conference table and said, "Honestly, Gwen, who's gonna believe you?" I smiled. Not because I was okay. I was shaking so hard I had my left hand pressed flat against my thigh under the table. But I smiled because I had been waiting 8 months for someone to say exactly that out loud. Let me back up. My dad died on a Tuesday in October. Pancreatic cancer, the fast kind. From diagnosis to funeral was 11 weeks. I didn't have time to process it while it was happening. I just drove back and forth between my apartment in Austin and my parents' house in Plano, doing laundry and picking up prescriptions and pretending I was holding it together whenever my stepfather, Roland, was in the room. Roland had been married to my mom for 3 years before she passed. Then he'd been around for 6 more years after that as what? My dad's friend? My sort of stepfather? My dad had remarried too, briefly, but that ended. Roland just stayed. He lived 2 streets over. He came to birthdays. He helped my dad move furniture when his back was bad. I never once questioned it, because my dad seemed to genuinely like him, and my dad was a careful man. He didn't keep people around who didn't deserve to be there. That was what made everything so hard to accept. My dad was a civil engineer. He spent 34 years building bridges in North Texas. He was meticulous about everything. His tools were organized by size. His files were color-coded. He balanced his checkbook by hand every single month, even after I tried to convince him that online banking was fine. When he set up the family trust before his first surgery, he sat me down at the kitchen table with a yellow legal pad and walked me through every single line. The trust was for me. The house in Plano, his investment accounts, a separate account he called the cushion, which had a little over $340,000 in it, mostly from the sale of a property my grandfather had left him in Abilene. He said, "This is yours, Gwen, not in a sentimental way. In a legal, documented, nobody can touch it way." He made me write down the name of the attorney who set it up. He made me repeat the name of the account. He died 9 weeks later. I was 29 years old. I worked as a forensic accountant for a mid-sized firm in Austin. I spent my days finding money that people had tried to hide. I want you to keep that in mind, because I promise it matters. Roland was executor of the estate. My dad had named him because, at the time the documents were signed, Roland was the most organized adult in my dad's life who wasn't me, and my dad didn't want to burden me. Those were his words, apparently. Roland told me that himself, at the reception after the funeral, while I was still holding a paper plate of food I hadn't eaten. He said it like he was doing me a favor, like it was a gift. I said thank you. I went home. I cried for 2 days. Then I asked Roland to send me the first accounting statement. He sent something. It was a 2-page summary document with no line items, no account numbers, no institution names. It listed total assets and said everything was in process. I asked for the full accounting. He said his attorney was handling it. I asked for the attorney's contact information. He gave me a name and a phone number that went to voicemail every single time I called. I sent a certified letter. I sent 3 emails. I called the trust attorney, the one my dad had hired, whose name I had written down, and left 4 messages over 2 weeks before his paralegal finally called me back and said, gently, that Roland had made arrangements for a transition of counsel. I sat with that phrase for a long time. Transition of counsel. My dad had been dead for 6 weeks. I called my cousin Patrice, who was a paralegal in Phoenix and who has never once sugarcoated anything for me in our entire lives. I read her the emails. I described the phone calls. I told her about the 2-page summary with no line items. She said, "Gwen, he's looting it." I said, "I know." She said, "What are you going to do?" I said, "I'm going to let him." She went quiet for long enough that I thought the call had dropped. Then she said, "Say that again?" Here's the thing about forensic accounting. The best cases, the ones that end with real consequences, with people actually held accountable, are the ones where you let the fraud run long enough to document the pattern. 1 unauthorized withdrawal is an error. 12 unauthorized withdrawal over 8 months is evidence of intent. I knew that. I had built careers on that knowledge. I had testified in 3 federal cases before I was 28. I was not going to hand Roland a one-time discrepancy that his new attorney could wade away as a clerical mistake. I was going to build a file so thorough that no one in any courtroom could look at it and pretend there was another explanation. So I let him keep going. It cost me sleep. I want to be honest about that. I would lie awake at 2 in the morning doing the mental math, running through what I knew was in those accounts versus what was probably still there. And my stomach would clench so hard I'd have to get up and sit in my kitchen with the lights off just to calm down. I'd think about my dad at that kitchen table with his legal pad. I'd think about him saying, "Nobody can touch it." I opened a spreadsheet on a personal laptop I bought specifically for this. Not my work computer, not anything connected to my firm's server. I labeled the tabs by month. I started pulling everything I could legally access: public real estate records, business filings, court records in Collin County and Dallas County and Denton County. I called the original trust attorney again and told him I believed the trust was being misappropriated. He was cautious, but he gave me enough to confirm which financial institution held the primary account. That was enough to start. Roland, I discovered, had formed an LLC 3 weeks after my dad's funeral. It was called Harwick Property Solutions. The registered address was a UPS store in Frisco. The sole member was Roland. The formation date was November 9th, 8 days after my dad was buried. I found 2 more after that, one in Oklahoma, one in Nevada. I documented everyone. I documented the dates. I found, through a contact at my firm who owed me a favor and agreed to run a search on a hypothetical, that Harwick Property Solutions had received 2 wire transfers from an account at a regional bank in Dallas. Transfers that totaled just over $200,000 in the first 4 months after my dad's death. I never told Roland what I knew. I kept calling. I kept sending polite emails asking for updates on the estate administration. His attorney, a man I'll call by his professional credential rather than his name, because I want to be accurate, and what he was doing was practicing law, sent me a 3-paragraph letter in February saying that the estate was complex, that the timeline was appropriate, and that my inquiries were creating unnecessary friction in the administration process. I saved that letter. I printed it. I put it in a physical folder I kept in my car because I didn't want it in my apartment in case anything happened. In March, Roland came to Austin. He called and said he wanted to take me to dinner. He said he was worried about me. He said I seemed isolated, that grief could do strange things to a person, that he wanted to make sure I was getting support. I went to dinner. I ordered the salmon. I listened to him tell me, over a $40 entree, that he thought it might be a good idea for me to speak to someone, a professional, because I'd been sending a lot of emails and he was concerned about my state of mind. I said, "That's thoughtful, Roland. I've actually been seeing someone." I hadn't been, but I wasn't going to give him anything. He nodded. He looked relieved. He paid the check. 2 weeks later, I received a letter from a psychiatrist, a doctor, whose name I recognized as being on the board of a small private practice in Dallas, stating that, based on a review of communications provided by the estate executor, he had concerns about my capacity to manage my own affairs and was recommending that I be evaluated for a court-appointed guardian. I read that letter 4 times. He had never met me. He had never called me. He had never sent me a form, a questionnaire, a request for records. He had reviewed emails I sent to an estate attorney asking for line-item accounting of funds that were legally mine. And from that, he had written a letter suggesting I might not be competent to handle my own life. I took a photo of the letter. I emailed it to Patrice. Then I called my own attorney, a woman named Kay who specialized in trust litigation and who I had found 3 months earlier specifically because I knew this moment was coming. And I said, "He found a doctor." She said, "Good. Now we have one more piece." Kay filed for a formal accounting and removal of executor in April. Roland's attorney responded by filing a petition for a guardian ad litem, citing the psychiatrist's letter. The case was set for a hearing in June in Collin County Probate Court. I took the week off work. I drove up to Plano on a Sunday night and stayed in my dad's house, which I still had keys to, which was still technically an estate asset, which Roland had not yet managed to transfer out from under me because the deed required probate court approval, and he hadn't pushed it through fast enough. I slept in my old bedroom. I put my folders on the kitchen table, the same table where my dad had sat with his legal pad, and I organized everything by date, by account, by entity. I was not shaking on the morning of the hearing. I want to be accurate about this too. I was tired. I was sad in a way that had become so familiar it almost felt normal, but I was not shaking. Roland was already in the courtroom when I arrived. He was wearing a suit I'd never seen before, a dark charcoal that looked new. His attorney was beside him, a man who was well-dressed, confident, the kind of attorney who seemed at ease in rooms like this. They didn't look at me when I came in. His attorney stood first and laid out their position. He said I had been exhibiting signs of emotional instability following my father's death. He said I had sent dozens of harassing emails to the estate attorney. He said a licensed physician had reviewed my communications and had concerns about my mental state. He asked the court to consider whether a guardian ad litem was appropriate before we proceeded to any accounting. The judge, the Honorable Judge, Therese Mallard, who had been on that bench for 9 years, who had a reputation among probate attorneys in Collin County as someone who read every document in front of her before she set foot in the courtroom, made a note. She did not look up. Kay stood and said that we were prepared to address the guardian question, but requested the opportunity to first present evidence relevant to the estate administration. Judge Mallard said, "Go ahead." Kay walked to the bench and submitted our exhibit binder. It was 47 pages. She had color-coded tabs. She started with the trust document. She walked through the original account balances as of the date of my father's death. She submitted the wire transfer records, obtained through a subpoena Kay had filed in April, which Roland's attorney had fought and lost. She put up, on the screen the court had in front of it, a timeline of transfers from the estate account to Harrick Property Solutions and its 2 related entities. Total amount moved out of the estate accounts in 8 months, $263,000. The room was very quiet. Kay then submitted the letter from the psychiatrist. She noted, clearly and without drama, that there was no record of any examination, any phone call, any questionnaire, any patient intake form, any clinical contact whatsoever between Dr. Whoever and me. The letter was based entirely on emails I had written asking for financial documents I was legally entitled to receive. She asked the court to note that I was a licensed forensic accountant. She submitted my professional credentials. She submitted a list of the cases in which I had provided expert testimony. Then she said, "Your Honor, may I ask the court to consider that my client sent those emails because she recognized professionally what was happening to her father's estate?" Judge Mallard took off her glasses. She set them on the bench in front of her. She looked at Roland's attorney and said, "Counselor, I'd like to understand something. Your client is alleging that this woman is mentally unstable, and your evidence for this is that she kept asking for financial records?" Roland's attorney said something about context and the totality of communications. The judge said, "Is there any documentation that Dr. Paz?" She looked at the letter, "that this physician met with or spoke to your client's stepdaughter at any point?" There wasn't. There wasn't because it hadn't happened. The judge looked at Roland, not at his attorney. At Roland, she said, "Sir, do you understand that presenting a letter of this nature from a physician who has had no contact with the subject as evidence of mental incapacity, do you understand what I'm going to do with that?" Roland said something I couldn't hear. Kay stood up and said, "Your Honor, we'd also like to raise the question of the letter's origin. We have reason to believe that Dr." and she said his name clearly into the record, "is a former colleague of Mr. Roland's brother-in-law, and that this letter was solicited, not initiated." She submitted the documentation. It was 3 pages. It showed a connection between Roland's family and the physician through a professional organization, and it showed that the physician had received a payment of $3,000 from Harrick Property Solutions. The LLC Roland had formed 8 days after my father's funeral, 2 weeks before the letter was dated. Roland's attorney asked for a recess. Judge Mallard said no. The hearing lasted another 2 hours. At the end of it, the judge removed Roland as executor. She appointed a neutral administrator. She ordered a full forensic accounting of the estate, which was almost funny, honestly, given my profession, but I kept my face still. She referred the matter to the Texas Medical Board regarding the psychiatrist's letter and the payment documentation. She referred the financial conduct to the Collin County DA's office. She did not yell. She did not editorialize. She just said what was going to happen, in the same clear, even voice she'd been using all morning, and then she moved to the next item on her docket. In the hallway afterward, Roland walked past me without speaking. His attorney walked past me without speaking. Patrice had driven down from Phoenix. She hadn't told me. She just showed up that morning, sitting in the gallery, and she was waiting for me outside the courtroom. She didn't say anything either. She just put her arm around me and walked me out to the parking lot. I stood in the sun for a minute. The parking lot was full. It smelled like asphalt and someone's lunch from the taqueria across the street. I thought about my dad. I thought about his legal pad. I thought about him saying nobody can touch it with such certainty, like certainty was a thing you could leave someone in a will. I thought about how he chose Roland, because he didn't want to burden me. The forensic accounting, conducted by the court-appointed administrator over the following 3 months, confirmed $263,000 in unauthorized transfers. Roland's personal accounts did not have enough liquid assets to cover full restitution. The court ordered the sale of a lake house he owned in Granbury, a lake house he had purchased in December, 6 weeks after my dad died, for $190,000 cash. I never asked what happened to the remaining difference. I know the legal process. I know it takes time. I know restitution doesn't always come in full, and I know justice in a courtroom doesn't erase the 8 months of lying awake at 2 in the morning, the dinners where I smiled and said nothing, the letter from a doctor who had never looked me in the eye. But I kept my dad's house. The title transferred to me cleanly in October, exactly 1 year after he died. I drove up on a Saturday and sat in the kitchen for a while. I didn't do anything particular. I just sat at that table where we'd gone over the legal pad together, and I let myself be in the room. The psychiatrist surrendered his license voluntarily in January before the medical board completed its investigation. I found out from Kay, who mentioned it in a brief email. I read the email twice, and then I closed my laptop and went for a walk. Roland, as of the last filing I'm aware of, is cooperating with the DA's office. What that means, practically, I don't know yet. What I know is that my dad spent 34 years building things that were meant to hold weight. He built them carefully, with attention to what happened when stress was applied in the wrong place. He taught me, by example, to understand how things fail. I used that. I used every bit of it. And the trust, his trust, in both senses of the word, is still standing. People ask me sometimes how I stayed calm through all of it. And I never quite know how to answer that, because calm isn't really the right word. I was terrified. I was grieving. I was doing the math in my head at 2 in the morning on the floor of my kitchen, running numbers that made me want to scream. Calm wasn't what I had. What I had was a decision, a single, clear decision I made early on, that I was not going to let my emotions move faster than my evidence. That decision cost me things. It cost me sleep. It cost me months of sitting across dinner tables and nodding and saying nothing when I wanted to say everything. There were nights I genuinely questioned whether I was doing the right thing by waiting, whether I was being careful or just afraid. Whether patience was a strategy or a way of avoiding the confrontation, I didn't know how to start. What I came back to every time was what my dad actually taught me. Not in words, necessarily. He wasn't a man who gave speeches. He taught me by doing, by showing me what it looked like to approach a hard problem methodically, to not let frustration make you sloppy, to understand that the difference between something that holds and something that fails is almost always in the details. Nobody bothered to check. Roland counted on nobody checking. That was, in the end, his entire plan. He counted on grief making me distracted, on my being young enough to feel uncertain, on the general assumption that someone who has just lost their father is too undone to read a wire transfer record carefully. He was wrong about all of it, and not because I'm extraordinary. He was wrong because he fundamentally misunderstood what loss does to some people. It didn't make me foggy. It made me very, very focused. I think about the psychiatrist sometimes, the one who wrote a letter about my mental state without ever speaking to me. He had credentials. He had a license. He had presumably spent years in a field built on the principle of doing no harm. And he wrote that letter for $3,000 and a professional connection, and in doing so, he handed us the clearest evidence of coordinated bad faith that we had. He thought he was helping Roland. He was actually finishing the case for us. There's something almost elegant about that, in a grim way, that the most damning piece wasn't something I had to find. It walked into the courtroom on its own. That's the thing about dishonesty at that scale. It requires so many moving parts, so many people willing to bend, so many small decisions that each feel low risk in the moment. And every one of those moving parts is also a point of failure. Every person who agrees to do something they know is wrong is also a person who can be documented, subpoenaed, cross-referenced. Roland didn't build a scheme. He built a liability. I kept my dad's house. I sat in his kitchen at his table in October, 1 year after he died. I didn't feel triumphant. I felt tired and sad, and underneath all of that, something quieter, something I can only describe as settled, like a thing had been finished correctly, like I had handled it the way he would have wanted it handled. He built bridges for 34 years. He cared about whether things held weight. I think he would have understood.